May it please your Lordship. Your Lordship, I beg to mention item number 19 and 20. These are analogous matter, and here we are supposed to file our written argument. So I pray for further 1 week time to file my written argument. I am for the appellant in this case.
Appeal.
Appeal.
Have you filed yours?
Lordship, so far as state is concerned, it's ready. We can file. It's ready. You can file at any time. But
This is with regard to that first track court
yes, first track court, Your Lordship.
on pre-made by the appellant, seeking more time, some more time to file the written argument. The same is allowed. Let the written argument be filed within 2 weeks. List the matter accordingly.
Oblige, Your Lordship.
Highly obliged.
1928.
Please, Your Lordship. Lordship, I beg to mention item number 10. We pray for 2 weeks' time. Your Lordship, the conducting counsel is out of station.
You are for?
The respondent, Your Lordship.
For the petitioner, Lordship.
Any objection?
No objection. The follow informed us, Lordship.
On pre-made by the respondent, not objected to by the appellant. This is matter to 2 weeks.
Highly obliged.
Lordship, I beg to mention item number 12, Lordship.
You are for?
I'm for the petitioner, Lordship.
I'm appearing on behalf of respondent 1 and 2, Your Lordship. 1 and 2.
Any objection?
No, Your Lordship.
You are in this case, Mr. Jha?
Yes, ma'am. My lord, item number 13.
12.
That 12.
12 and 13, same.
No, my lord. No,
Okay,
my lord.
so
It's a-
let us finish this one. 12 first. On pre-made by the petitioner, not objected to by respondent. List this matter to 2 weeks.
Lordship, similar prayer for item number 18, Lordship.
Appeal
2 weeks' time, Lordship.
on pre-made by the appellant on the ground that the learned conducting counsel is indisposed, but is adjourned as prayed for. Only on prayer. List this matter to 2 weeks.
Obliged, Lordship.
My lord. Item number 13 that pertains to the promotion. My lord, they had to produce that DPC proceeding, my lord.
Yes, that one.
Yes, my lord. So,
Lordship, we have already received the instruction, Lordship. Lordship, the learned DSGI will make his submission.
So we'll
Lordship, but I humbly pray if this matter can come up after 2 weeks, Lordship, because we are not prepared.
yes, on pre-made by the respondent. List this matter to 2 weeks. Not objected to by petitioner. To 2 weeks.
my lord.
Highly obliged.
From supplement cost list, item number 1.
Your Lordship, the matter may be passed over. Your Lordship, my senior is coming. Your Lordship.
I think I'll not be able to take this matter. It so happened that I know both sides. It's not that I know only one side. They are my neighbors. So I don't think it's proper for me to list this matter before any other bench than this one.
Item number 2.
My lord, this is the first appeal we filed against the order passed by the Special Judicial Officer Reference Court, dated 17th July 2023. Now, the brief fact of the case here is, my lord, the appellant, the cooperative apex bank, require a place for construction of its office. Therefore, a request made. The state government has issued a Section 4 notification on 30 June 1987. And the 1988 Section 6 declaration was done. And subsequently, my lord, the proposed area to acquire was 480 square meter in Police Bazaar. Now, during that process, the respondent number 1 claimed that part of the land he had started construction. Therefore, he came to the High Court, the then as well Guwahati High Court. And Guwahati High Court entertained his petition, writ petition, and directed the government to reduce the area. So from 5,000 square feet was reduced to 3,000. So the High Court directed the government to re-modify and issue the Section 6 declaration. Accordingly, the Section 6 declaration was issued in 1993. And thereafter, he filed the second petition again before the High Court, saying that the Section 6 declaration was done without a proper survey. And number 2, after expiry of 1 year from the date of issuance of the Section 4 declaration notification. So High Court entertained his petition again and directed the government to conduct proper survey and, in the presence of the parties, demarcate it, divide the property properly, and issue the modified Section 6 notification. So accordingly, it was done. In 1993, my lord, the collector passed a award fixing 80 rupees per square feet and asked him to come and collect the award. Now, he said that amount was inadequate. And then when he came for collection, the then collector insisted that before you collect this 3,68,000, the compensation amount, you have to deposit the ad valorem fees to the authorities. So being aggrieved, he went to the High Court again, third time. And High Court single bench accepted his contention that payment of ad valorem fee doesn't arise for accepting the compensation. Matter went to division bench also, and the division bench also upheld that one. And subsequently, my lord, matter proceeded, and the High Court allowed him to put up the application for Section 18 reference application. Now he has done after more than 13 years, if we count from the date of Section 4 notification, passing of the award. Award was passed on 18 April 1993. Now, if we count from there, then he filed the Section 18 application in 2006. So even if excluding the litigation period, then he filed the application more than 2 years. So thereafter, the collector entertained and matter was referred to the reference court. The reference matter was faced a full trial, and recently the trial court passed an order extending, my lord, the enhanced amount from market rate of 80 rupees to 800 rupees. 10 times the earlier amount. And I'm agree with that. Number 2, the reference court has relied on the sale deeds, say the 30 December 1993. Now that was, the sale deed was after, the sale deed was registered after Section 4 notification. And Lordship is aware, for determining the market value, the prevailing market value at the time of Section 4 notification is relevant. But here, admittedly, the learned trial court relied on the sale deeds, which was registered much after the Section 4 notification. That is one of the grievances. And number 2 grievance is, my lord, here the sale deeds, selling plot of land in Police Bazaar, amounting to 5 lakhs. Now that includes the house and the land. It comes around at 560 per square feet, something, including this both house and the land. But the learned trial court rely on that, and even given much beyond this 560 per square feet, she has given 800 per square feet. So my certain grounds are, my lord, limited grounds we have placed before this honourable board for consideration. So there are quite strong grounds are there. If Lordship admit the appeal
Yes,
and
I think
fix
we
the early date for hearing. And we also desire for early disposal.
Malad, land acquired is in Plus Bazaar. Malad, I was paid 80 rupees a square feet. So Lordship is well aware. They are saying that it's the market value, Malad. Whether that will be possible. The delay, as far as the delay is concerned, Malad, I had received the notice under section 12(2) of the 1894, Malad.
The appeal will be admitted.
Malad.
You have accepted notice?
Yes, yes. Only thing is, Malad, I think proper court fee have to be paid by them also, Malad.
Oh, court fee?
No, I think they have paid only the fixed court fee, Malad.
Not the ad valorem?
Not the ad valorem, Malad.
That is for the registry to...
Yes, Malad.
If it has passed muster, then what do we do?
The appeal was accepted as it is. But we will take further queries from the registry. And if required, we will definitely.
If that is required.
If that is required, it's our duty to pay.
They have paid only the fixed court fee, not the ad valorem court fee.
We'll verify from the registry. In the meantime, Lordship may admit this one, and the record may be called for and fix for early date.
We will first.
You have to prepare the
paperbook
yes,
also. They'll have to first the ad valorem court fee hurdle have to be passed.
Registry, this court will direct the registry to look into that. And you inquire on the registry?
Yes, we can do that. In the meantime, record may be called for.
Chal. Sangreso landed senior counsel appearing for the appellant. On hearing the direct senior counsel, on consideration of the submission made, this court is persuaded to admit this appeal. The respondent is also represented by Mr. L. Kriam, Learned Counsel, who has accepted notice, and as such, no formal notice is required.
My lord, respondent number 3 also is there, my lord, the collector.
How many respondents are there?
3.
Three we have served to the.
3 is the collector.
Oh, I thought you're.
My lordship may allow us to serve copy to the.
Yes.
Government.
Respondent number 1, no?
No, 1, 2 I'm appearing, my lord.
1 and 2.
2 is the collector. 3 is the collector.
As far as respondent 3 is concerned, the appellant is to issue notice.
Yes.
The same returnable within 2 weeks. On an objection raised by the Learned Counsel for the respondent number 1 and 2, on the issue of payment of ad valorem court fee, which according to the said Learned Counsel is inadequate. The Learned Counsel for the appellant has submitted that he may be allowed to confirm from the registry.
Yes.
And to correct the same if required.
If required.
Registry is directed to look into this matter. Upon admission of this appeal, the records from the trial court is required to be produced. The same are hereby called for. After the records have come, then the paperbook will be allowed to be. Otherwise, where will you get the materials from?
I know it.
2 weeks, no?
Item number 3.
May it please your lordship. Lordship, I'm praying if this matter may be listed at the end of the board, lordship.
I suppose. End of the board.
Highly obliged, lordship.
Assembly causeless. Item number 1.
Lordship, here they are supposed to file their rejoinder.
Who is to file?
Lordship, we are supposed to file a rejoinder, lordship. As of now, lordship, I do not have the instructions from Mr. D. Thaba, lordship. He's the one handling the matter. He's on his way, lordship.
You have not received copy then. So it must have
They have not filed. They have. It is prolonged matter, lordship. We have filed our affidavit. It's long time back.
So we'll wait, let him come.
Applied
This is
lordship.
related to the earlier.
No, Lordship, this is just this is a miscellaneous, this is other case, Lordship. It is not related. It is challenging the notification, Lordship.
Oh, that not fine.
It is challenging the notification, but that case is for EPF dues. So the matters are two separate matters.
Fine.
Applied lordship.
So
Item
Lordship,
number 2.
this will be again end of the board, Lordship, this matter?
Yes, Mr. Thaba is on his way, so in any case, you will be there for the other case.
Okay.
We'll wait.
Item number 2.
My lord, I'm for the disease respondent number 5. Due to poor network, we could not contact the client, so I prefer another 2 weeks time.
This is only to bring on record the
Death certificate, Your Lordship.
We have to there was some
Typographical error.
clerical error for that.
Mr. S. Sangija, the counsel for the respondent number
5.
5, who is since deceased, has submitted that due to specific instructions not forthcoming, the correct information, or rather the death certificate, a copy of the death certificate could not be produced before this court formally. It is prayed that some more time may be allowed for the same to be brought to the notice of this court, even by way of an affidavit. On prayer made, accommodation is accorded to the respondent to the land council to take necessary steps. This is matter to 2 weeks.
Item number 8. Some time.
Yes.
Lordship, we have already received the instruction, Lordship, from the department, but the learned DSGI, he'll make its submission. However, Lordship, we are not prepared today.
They have made it very clear, see, not only on one occasion, but on many occasions, that 2017 matter.
Lordship, I pray for some more time, Lordship.
I'm correspondent number 3. Let's check my services will cover the salary. Don't you
You are for respondent 3. You are still in service. Maybe.
Respondent number 3 retired.
Or retired. So that means your pensionary benefits have not been.
Benefits have been, retirement benefits.
That is on account of this, because of this pending proceedings here.
My lord, I believe that though I'm not representing, just to assist, my lord, it may not be necessary to withhold, because now, my lord, this is an admission, has not been admitted this case, my lord. So there's no embargo actually to hold some.
Yes, but who has done that? If there is no specific order by the court, then
yes, exactly, my lord.
Then they should have. You make a petition before the authorities concerned.
In fact, NEC, who was the funding agency, they themselves has asked for closing of this project, and we have also brought on record that this project has been, so far as the NEC fund has come and utilization certificate, everything has been submitted, and funding agency is satisfied with that, and they have directed us to close their account. So when they are satisfied with that, there is no question of, I do not know why they are holding his pensionary benefits.
Who are you?
Extension officer of North Eastern Council.
Okay, you're okay.
Yeah. So they themselves are not aggrieved. It is the CBI who has filed. So a funding agency is satisfied with that and they are closing their project.
Then it's for you to take the issue. By this time, you should have a, make a representation before the authorities concerned, state your case, and if they, refuse to do so, then you can file, an application before this court, and see orders will pass. But in all probability, it would be better if we, get the matter disposed of.
Yes, my lord.
But again, time and again, you have sought for time. So when do you want it?
Not
1
sure.
week? Please think about his.
When your lordship will fix that matter?
So 1 week?
Tomorrow.
No, 1 week.
Oh, 1 week.
If you are ready tomorrow, what then tomorrow?
Next week.
Lordship 1 week.
Please do. Should we fix a date? We'll do it on 12th then.
My lord?
Should we do it on 12th? That's next week.
12th. Yes, dear. 12th.
The petitioner appearing to Land Council has submitted that the necessary instructions have been received. However, since the Leonard DSGI is not available today to take up this matter, the prayer has been made that this matter may be carried over to the next date. As prayed for, the same is allowed. It is made clear. It is, however, made clear that no further adjournment will be allowed in this case.
Okay.
As agreed to by the parties herein, this is matter on 12th.
Highly obliged.
Item number 9.
My lord, there is a small request. This matter can be taken after puja, my lord. I have taken the consent of my friend. He has no objection to it.
Fine. So, anything?
I have no objection, Your Lordship. He has made a request.
You are for respondent?
I'm for respondent district council, my lord.
Yes, this council is what respondent?
1, 2, my lord.
1 and 2.
Yes.
I'm for the petitioner, Your Lordship.
You are for
For Your Lordship. Actually, 3 because 3 is not contesting the district.
It has proceeded ex parte against 3.
Yes, yeah. Yes, Your Lordship.
Mr. S.D. Leonard standing counsel for the respondent.
1 and 2.
1 and 2. GHADC has submitted that this matter may be adjourned for the day on the ground that he is not prepared for the same today. On the petitioner not objecting to the prayer made, the matter is adjourned. Let's just say after 2 weeks.
After puja, my lord.
That's 2 weeks. So it's now 1, 2.
First week of November.
3 weeks.
3 weeks. Hello.
Item number 11.
Where's Mr. Nopior?
Come after
Keeping.
Apologize, Lordship. Missed out the item. Lordship,
What are your instructions?
Lordship will pursue the matter, Lordship. Because that is the prayers to. We are praying for retrospective promotion. And so,
But
we'll
he
be
has-
contesting the matter, Lordship.
But he has been promoted as of date.
As what date, yes. Now the only issue is that retrospective.
Retrospective.
Will come after 1 week, Lordship.
Let it after puja.
Because the only issue here is that they have rejected my promotion, saying that it will create a floodgate litigation. That is only ground they have taken.
We'll see if that ground is valid or not.
We have some judgments to substantiate that.
On premier by the Mr. M. L. Lupio, letter counsel for the petitioner, has submitted that he has received instruction to pursue with this matter and accordingly has prayed for another date for the same to be heard. Finally, on premier, this is matter up to 3 weeks. Obligation.
Item number 14.
My lord, it is a part heard matter. Now that AG is supposed to complete his, conclude his submission.
AG is on lag before another courtroom.
Okay, my lord, I was informed that in the last occasion, AG informed the court that he has concluded his submission. In that case, may I give a short rejoinder?
Has he?
That was the submission made on the last occasion, Manoj.
Yes,
He
conclude.
was present and he had said that.
But I know he did say that he'll continue. Then I
First
think that,
occasion, we argued, me and my friend, and matter was adjourned after 2 weeks. He argued, he was inconclusive, and thereafter matter was posted again. He made short submission, and later on he said he concluded his submission.
yes, Mr. Abraham, what do you say?
Let my senior counsel advances argument, and if need be, we'll reply it. Otherwise, we'll just file it.
We cannot go on like this.
An ending exercise.
They have already, argued. You have replied.
Yes.
Now on no points they will
Yes, only short rejoinder from our side.
rejoin. But if you have not completed, I mean, if
Yes.
so I don't recall correctly. I did, if I may be wrong, but I did recollect that he said that he will some more points to be covered, which I think that day there was a paucity of time or something. I don't exactly. I don't.
And if that be the case, Lord, your Lordship, if this matter may come up on Monday.
No, he's here.
Yes, he's on. I mean, he's too busy. He's on to another courtroom.
Monday,
Monday.
Subject to lordship convenience. We can conclude it.
Okay. On premier by parties, let's this matter on Monday, 9th.
I'll update your Lordship.
Item number 16.
Yes, Mr. Khan. Today somebody, everyone is.
Maybe because
Are you?
weather?
Looking at you, I was about to say that you are in the puja mood, but you are obviously not.
Not obviously.
Actually, we were discuss something and overheard.
So you have to file the amended.
We have filed it.
You have filed.
We have filed it on the last date.
Okay.
A copy has already been
I
served.
received the copy.
Regarding, there was some correction.
Yes, only on that.
Yes,
the date.
minor
So
correction.
do you have any objection to that?
No. It's just a date correction.
Yeah, that's all.
It's just a date. Had it appeared only once, it would have been okay. But it appears,
Correct.
a number of places.
Yeah, because that the date of award and the date of judgment, inadvertently the date of award was mentioned.
Okay.
Because there were 2 days. It was pronounced in the open court, so I took that as a date of judgment. But in fact, the date of judgment was different, which the court had rightly pointed out. this matter can fix for judge.
Mr. Khan, counsel for the appellant, has submitted that the amended memo of appeal has been filed, to which the learned counsel for the Ms. Shadi, learned counsel for the respondent, has submitted that no rejoinder is required in this matter. I think what we can do, since this matter has been, put on hold for quite some time, if you can just refresh the court on the factual aspect. I believe you have also filed your
Written argument we have filed.
Written file. We have filed our respective written argument.
Just briefly. Can you do it now?
Malad, I was of the view that since the mail file is...
We'll put it next week then.
Next week.
Next week.
Okay.
You're okay with that?
Next week.
Week.
That will come up on...
It will come up on 9, 10.
Yes. Any date?
Maybe after 2
10.
weeks, because some...
No, after 2 weeks Durga Puja will be there.
Either that or it goes to the last week.
Then it will go to the yes.
Last week.
Last week.
We'll refresh the call.
Okay.
Because basically my argument will be confined.
So we'll do it after Puja.
Yeah, man. Confined to the written argument.
Lordship, not on 31st only. Let it come on 30th. Not on 31st, because 31st I have a matter already fixed in Guwahati. So
then we'll have it in the first week of November. Then.
Yes, madam. First week.
First week, okay. First week of November.
Or rather, you see, there would still be the week after that. So we can have it on the second.
Second week of.
2nd of November. That will be Thursday.
2nd of November.
Okay with that?
Okay.
Madam.
The parties have submitted that they may be allowed to refresh the court on the facts and circumstances of this case. As prayed for, this is matter on 2nd. So it's a fixed date, so please.
Yes.
Thank you.
Item number 21.
May it please your lordships,
Yes, Mr. Kushit, tell me.
well, your lordships recall we had addressed your lordships for a while, and thereafter there was the matter was interrupted because there was a change of roster, and it's come back to your lordships again. So, my lords, there are 3 documents that my colleague is in court will place before your lordship. Your lordships will just be kind enough to receive those documents. Well, that's only.
Nobody is here. Nobody is here on your behalf.
Sorry, I'm sorry, Malaz. I was given to understand they would be there. There are just.
Municipality, are you?
Yes, Lordship.
You, Mr. Kushit?
Yes, Lordship.
Okay. I thought you are on your. You have your own case.
Yes. I'm here for this empathy also, Lordship, and for other matter also, Lordship.
Right. So he is here.
Lordship,
I'm grateful, my lords. Here's those 3 documents to place before your lordship. It is just for assistance of the court. These documents are only a compilation based on the documents that have been submitted by the CBI. So there's nothing new. It's only a presentation in a form that we hope would be able to amplify the arguments we're making.
Have you given
I
them?
think they will.
Have you given them a copy?
I'll give them one.
Copies of it. They seem very reluctant to.
And these were given, these 2 were taken, but I still ask them.
3. If your lordships will kindly see their document marked as 1, 2, and 3.
In this compilation?
Yes, Lordship.
In the compilation that my learned friend would have just given to you, my lords, it's document number 1 is for Jowai subdivision.
Yes.
It only provides the sequence in which the numbers are being given and so on. Document number 2, my lords, is from this is for Jowai, document 1. Document 2 is for Amlaram
At the last, my
subdivision,
lord.
something.
Joy is at the last, Lordship. We have marked as document 1.
Yes, yes, yes.
Document 1. And my lords, finally, document 3, I've just indicated that there is no pattern. My lords, to whatever extent that absence of a pattern between the recommendations made and what has been done. My lords, that's only to join the dots to explain that there is no pattern, and therefore this could certainly not amount to a grave suspicion situation. So, my lords, that's the 3 arguments that we are making before your lordship. So, my lords, if I may just begin with one simple proposition. My lords, I am appearing for A1.
Yes.
Your lordships had been very kind to hear me in the past. My lords, I'd requested your lordships to just consider that there may not be any occasion for me to argue that because I am in a special place, in a special position, therefore indulgence may be shown to me. That is certainly cannot be and must not be a cause for me to plead. However, my lords, it also should not be that beyond the ken of the standard that is applied to ordinary people, that a harsher and harder standard be applied to me, is all I urged your lordships to consider, but that's only the backdrop of this. My lords, essentially the claim against me, the charge against me is essentially that I received recommendations from public representatives. Recommendations saying, please help so-and-so, please help so-and-so, please help so-and-so, in the selection of assistant teachers. Those recommendations I passed on to A2. A2 was a director who was responsible for the actual work, etc. I passed on those recommendations to A2, and I concede that on some of those...
Therein lies your complicity.
Well, lords, I'm grateful your lordships have actually added that so that I'm conscious of what I need to answer. My lords, CBI has come to a conclusion that public representatives making recommendations, and these are not public representatives who don't know what the procedures are, what the proper actions to be taken are, but they still come and give representations. And I, as a public representative, but of course in a position where I can do something with those recommendations. If I do, I will be answerable, etc. Now, I take those recommendations, and my lords, with candor, I must admit, repeatedly they've said that my forensics have found my signatures, my handwriting, etc. Now, there is no way of my denying that. On the slips that I passed on, they are my handwritings. But on no lists that have been made, is there any handwriting? Well, this attempt to confuse as though my handwriting has been found on the list is not there. Your lordships will only note this. I will show it from the charge sheet itself, that my handwriting is nowhere on the documents that we are concerned with, but my handwriting is found on the slips that I got. Now, my lords, CBI comes to a conclusion that public representatives making recommendations is not culpable. It's not culpable. They've come to that conclusion. But, my lords, the logic then extends to the person who endorses those recommendations, unless it can be said that that person authorized and insisted or pressurized anyone to follow up the endorsement that that person did on those recommendations, to make a distinction between public representatives and a public representative who was part of the process of passing on those lists, passing on those slips, is something, my lords, that your lordships would consider whether such a distinction can be made. I agree, my lords, that I cannot say that somebody who is culpable, not being made culpable, should not be automatically a ground for me saying that I am not culpable. But, my lords, there has to be some propriety, there has to be some non-discrimination, there has to be some manner of approaching the whole issue that is consistent and logical. It can't be whimsical. It can't be that I don't look at somebody's culpability at all, but I consider you culpable, and therefore what might be a diffused kind of responsibility comes on one person. My lord, this is one argument, but your lordships may or may not accept it. I'm conscious of that.
The yardstick
But
that is applied could be subjective or objective for that matter, but that is
So, my lords,
that is
I'm
incumbent
grateful.
only on the investigating agency.
My lords, I'm grateful. I'm grateful. Your lordships have very consciously and carefully used the word subjective and objective. May I, my lords, just say that I would have to insist that the yardstick must be an objective yardstick, which is why I gave the preliminary point I made to your lordships that it has to be an objective yardstick, and the objective yardstick, whether it is objective or not, will be apparent from the fact that that yardstick is not applied to some people, but it's applied to me. That's only to say, am I faced with a higher standard than somebody else? I can't say that somebody else must also be made culpable. That's not my job, my lords, to actually ask for somebody else's culpability, but only to underscore the yardstick that is being applied. And your lordship will only keep that in mind. Just keep that in mind. So, my lords, this is the backdrop. This is the backdrop. But assuming, my lords, that I cannot persuade your lordships to be with me on this particular point, the next point is important, and I said the linking of dots is important. The next point that is important is what has happened with the recommendations that I have endorsed. Has it reached a culmination in a manner that could be said, as your lordships asked me? Will that not be complicity? Would that not be that you are complicit in forwarding something, getting it done? Yes, if I got it done, if there was pressure, if there was insistence, if there was an unlawful direction, then, my lords, I would, of course, be responsible, undoubtedly. But there is no evidence, my lords, anywhere, including in the charge sheet or, in fact, in the order that has been passed on charge. There is no semblance anywhere, even an iota of evidence to show that I used my authority, I used my position, and I used my power unlawfully, illegally, to pressurize somebody to do something that should not have been done. There may be a coincidence, and therefore, my lords, I want to show that the linking of dots is important for coincidence, because your lordship knows I'll place the judgments before your lordships for your lordship's convenience, but your lordship knows it has to be no ordinary suspicion. It has to be a grave suspicion, and facts would have to be made out for a grave suspicion. Your lordship also knows in Selvi it has been made clear by courts that it cannot just be that the trial court becomes the mouthpiece of the prosecution. The trial court just parrots what the prosecution says and accepts it. There can't be a mini trial, my lords, I concede. There cannot be a detailed analysis, because that is for the trial. It can't be done at this stage. But at the stage of charge/discharge, what is the extent to which the court can examine the facts that are available, my lords, are important, and that will be critical to my case before your lordships. So what is the extent to which facts have to be examined to decide whether there is grave suspicion or not? That is all the standard that I seek, my lords. There are a few interpolations. I use the word interpolation only to say that the facts that are not available in the charge sheet seem to have been assumed, as far as the order on charge is concerned, seem to have been assumed, linking the dots. For example, my lords, I'll take your lordships to that in a moment. For example, it is said that all the documents, all the lists that were prepared were taken by A1 and kept in her custody, by A1 in her custody. And then whatever alterations, modifications had to be done were done. And then in haste, the lists were released. Now, my lords, one critical missing link is the forensic report on the computer. All these things are said to have been kept on her computer, and that forensic report on the computer, the hardware of the computer, etc., the CDs from the computer, no forensic report has been placed. So a critical gap remains in terms of arriving at grave suspicion if it cannot be established, as it's seen from the charge sheet, if it cannot be established that the forensic report says that all these documents were available on the computer, or that they had been in the computer, they had been altered and new documents had been created. And the final document, which was the document that was issued, was finally a printout from those documents. My lord, that's a critical missing link, if your lordships would be kind enough to keep that in mind. My lords, that's the second point that I'm making. My lords, the third point, if your lordship will look at document 1.
Yes.
Well, it's the allegation, as your lordships have noted, is that there were recommendations made, recommendations were endorsed by A1, and on the basis of the recommendations of A1, alteration, modification, and whatever interference with the record was done is the basic cause of the culpability. Here I am just showing to your lordships the July subdivision in document number 1.
Yes.
So, my lords, your lordship will see at page 194, and we'll come to that in a moment. At page 194 is a list of candidates who qualified for appointment. This is at page 194. So, my lord, this is just a total list. This is just a total list. This is not a list which is in any order of descending order of marks or anything of that kind. This is just the list, if your lordships will see. And then if at all there is an alteration or there is an interpolation in this, I'll address that separately. Then your lordship will see the second column, which is from page 197. My lord, this is a list which is signed
page
by...
190, sorry, page 191.
At page 197.
Page 194 or 197 of what?
My lords, your lordships have the main petition. Your lordships have my main petition. And if your lordships would be good enough to go to page 194.
Okay.
Right. So, my lords, this is just a list which is signed by the director, which is signed by A2.
Yes.
Right. This is just a list. If your lordship will see, this is a list of candidates who are qualified according to A2. Now, this list, my lords, if your lordship will see, you will also go back to document 1 at page 197.
Yes.
At page 197, your lordships will see is the list which is signed by the entire committee.
Yes.
Yeah. So if your lordship will look at column 1, which is page 194, and column 2, which is 197, whatever is on 197 in a particular order is also in 194, though not necessarily in the same order, but they are also in 194. It's the same list. The list that is signed by all these members of the selection committee is the list that is finally prepared by A2, the director. So, my lords, there cannot be any question mark on these two lists. One is signed by all the members of the committee, and one is replicated by R2.
Yes.
Just copying from the list which is in column 2. Then, my lords, if your lordships will come to page 204 of the third column. In the third column, your lordships have page 204.
Yes.
Now, this, my lords, is just giving the score sheets marks that have been obtained. So it's only an amplification of the first two columns, but in terms of the marks that have been obtained by each person, by each of those candidates. So again, there is no interpolation of any kind, there is no interference of any kind. Finally, your lordships will see the last column. These are the consolidated score sheets and the score sheets with each candidate's marks. So these are only marks that in descending order from 43, the next 2-3 pages, they'll go down to 39. They'll go down to 39. There is no interpolation anywhere. My lord, this is just a simple. Huh?
Tampering allegations only on this sheet.
So, my lords, there is no allegation of any tampering here. So, where could tampering have happened? Where could tampering have happened is one question. So, my lords, the tampering could have happened only at. And my lords, this is a very critical, sensitive part of my argument. The tampering could have happened only at page 204. Is that right?
Yes, that's the allegation.
So the allegation, and that would be established from the charge sheet as well, is that tampering could have happened only at 204. Whatever tampering had to happen, if it happened at all, would have happened at page 204.
Yes.
And my lords, here there is an important point about linking the dots. My lords, if the tampering has happened in 204, which is the marks where different candidates have got, then that tampering has either happened before the charge sheet, before the score sheets were signed by the members, or after. Now, if the tampering happened after, they signed, then, my lords, the same names would not have figured in column 2 and in column 1, because it means that the members would have signed some marks, and then somebody tampered and then changed those marks. Then those would be different in column 2 and in column 1. And column 2, if your lordships will see, has also been signed by all the members. So, my lords, where is the occasion between column 3 and column 1, which is signed by all the members? It is not as though anyone has said that we signed the score sheets and then we left it to be tabulated. After the tabulation was done, 2 days later or some hours later, etc., then we signed that also. Now, lords, anywhere, if there had been interpolation and any changes in the marks that they had signed, then they would not have signed again. So there are 2 sets of marks that have been signed. Those marks are the same. In column 3, the marks that finally appear, with the allegation that there is tampering have been signed by members, and column 2, the same marks that have been reproduced in the consolidated score sheet have been signed by members. So who could and at what stage could anybody have interpolated? My lord, that's a big question. Be that as it may, your lordships may come to a conclusion that many of these questions can only be decided in trial and so on and so forth. But birds, I just want to take your lordships to one more document. Look, this is document 3. The lordships saw it last time, and in fact, this was given to the prosecution, to the learned AG, appearing for the CBI. That this is a document, my lords. I'm just showing this in order to indicate that there is no pattern. So if your lordships have page 1 of volume of document 3.
There's a mistake in page number, it's 187.
Well, look, this is taken from page 187. My lord, this is taken from annexure 8, which is the main document that the CBI have filed. Annexure 8, which is at page 187 of the volume that is before your lordship. But I've extracted this from annexure 8 just to show.
My lord, document 3 which I have given today, my lord.
Document 3 is here.
Yes.
Where's the corresponding document in
corresponding, my lord, it will be in the charge sheet. Here in the petition.
All on 187, page 187.
Yeah.
It will be here.
Please, Lord. So this is being taken from 187. Your lordship may just keep that in front of your lordship. If your lordship look at it for a moment, I won't take your lordship through the entire document. But if your lordship will see page 187, annexure 8, if your lordship will just look at the names that have come. So, the center is given as July. Then whether someone is being selected or not selected, and whether in the second last column whether there has been any tampering. And if your lordship will just see from the top, the first name, Srimati Damisa Kia, she is being selected, and there is a tampering, yes, indicated by CBI that there is tampering. Then, my lords, there is tampering in name number 2, name number 2, but there is no selection. She's not selected. It's been tampered but not selected. Then, my lords, all these others who are recommended, including number 10, have not been selected, although there is tampering. So number 2 and number 10 have been tampered, but they have not been selected. Now, lords, it makes no sense to me, if I may admit, that there is tampering on someone, but that person doesn't get selected. Then my lords, again, number 12, not selected, but tampered. And then, my lords, this one is recommended at number 13, but not tampered. Selected, but not tampered. Then your lordship will see number 28, selected, but not tampered.
Yes.
So similarly, my lords, if I could take yourself down the list. So what I've done is that in document number 3, I've extracted this, I've summarized it. So I will show which have been selected and tampered, which have not been selected despite tampering, and etc. etc. So if your lordship will just see document 3.
Yes.
Similar, the first item there, this is taken from page 103. The first 3 are taken from page 187, and this one is.
Next page.
Similarly, your lordship will see one Mr. Lalu has made some recommendations. There are 37 in the list that has been seized, 37 recommendations. And there is a remark, if your lordship will see, to be listed, bring up, etc. There is a remark, I must admit. And this remark is only in 25 of the 37. This remark is not everywhere. 13 of the 25 where there's a remark have not been selected. 1 is selected but not tampered. And then 6 are selected who are tampered. Well, I'm only showing this for a pattern that simply saying, if your lordship recall, your lordship said, aren't you complicit if you're passing on these recommendations? And I said, passing on the recommendations doesn't seem to be the critical matter that has taken place, because the recommendations, by looking at this breakup, are not recommendations that lead to a selection inevitably. So something else seems to have gone into the selection process. How that has been done is not made clear as far as the charge sheet is concerned or the order on charge is concerned, which is why I say that grave suspicion is not made out. If your lordship will please see Mr. S. Dhar,
Yes.
where a total number of 39 lists were found. Only 29 have remarks written against them. 2 of those have not been selected. 2 were selected that did not require tampering. 25 have been selected and tampered. Yes, my lords, this is some who have been selected and tampered. And similarly, my lords, coming one, Yambone, again, 34 out of 77 are selected and tampered. 3 are not selected, etc., etc. But the important thing, my lords, is now to come to page, which is this page?
This is not important because
No, which page is it? Anyway, my lords, if your lordship will, 160.
it's the complete set of
If your lordship will now see what has happened with others. So if your lordship will just see the bottom few selected and tampered without a note. So there's no note, but they've been selected because of tampering, or let us say because they have been tampered. But there is no note, my lord, so they cannot make A1 complicit when she has not even written a note. And your lordships will see this goes on from number 1 to number 21. So 21 are in the category where they are selected.
You're referring to page?
My lord,
page 190.
this is page 190. This comes from page 190, but this is summarized on the first and the second page of document 3. So, my lord, this is all accurately taken from the records that are placed. So here, your lordship will see numbers 1 to 21. They are not, they are selected and tampered, but there is no note. Well, that the documents show very clearly. Then, if your lordship will see, there are 11 in the middle of the page. There are 11 who are selected and they are tampered, and there's a note. So there are 11 where, as your lordship said, there can be grounds for complicity. Selected and tampered with a note, there are only 11, whereas 21 had been selected without a note. Then, if your lordship will see the third category, selected, not tampered, without a note. So these are people who cleared on their own. There is no problem. There is no note, etc., and there is no tampering.
Yes.
Then, my lords, the next category, selected, not tampered, with a note. Without tampering, the note has meant nothing because they've been selected without tampering. That means they've been selected on merit, and therefore the note would be infructuous. And this, my lord, starts there with 1, 2, and the next page, the last page, are 3 and 4. So, my lord, my argument here only is that, one, it is not clear at what stage the tampering was done and whether there was an opportunity for tampering at all, which is the first argument I made. Secondly, that there is no clear pattern that wherever a note is given, wherever directions or a note is given, that there is tampering and the person is selected. Many people get selected on their own, but there are some who have been selected with tampering. But the question is, in the lack of a pattern where someone has said, please do this, and it is being done with tampering, there is no such pattern all along. So for what purpose and at what reason somebody would have tampered, my lords, I am not able to judge from the manner in which the the charges have been framed. Now, Lords, I will not like to say anything at all, which suffers from what is called the prisoner's dilemma, that I say something to ward off any action against me and palm it off on somebody else. I would not do so. But I know that A2 will be arguing, my lords, and the A2 will have to place their own case before your lordships. But it is very clear that no statement of 161 or 164 made by A2 implicates me at any stage to say that this is what happened and I was told to do this, therefore I did this, and this is the manner in which I did it. So, my lords, in all fairness to A2 will argue their case before your lordships, and I only want to say that I have no role at all, and therefore it will be unfair for me to say somebody else has a role, I don't have a role. There's no question. I'm not saying that. A2 must have their own right to be able to argue, and they will argue, I'm sure, after I finish. So, my lords, this is broadly the case that I have, and I will give it to you, lordship, in a written submission as well. My lords, may I take your lordships now to the file once again, and if your lordship will see how the charges have been framed.
Yes.
My lords, I'll take your lordship directly to the impugned order. Well, this begins at page 44. It's annexure 1.
Yes.
Well, page 45, 46 is the narrative of the complainant, how the complainant came into the picture, and then the matter was given over to CBI for investigation, and the investigation, CBI files the charge sheet against A1, A2, and A3, challenging the alleging offences under 120B. So I'll give your lordship judgments on 120B, 420, 467, 468, 471, and 201. So, my lords, I have serious doubts about 420 because, my lords, there is in 420 property has to pass and so on under misrepresentation. But I'll leave that for a while. Issue really is whether there is a section 13.1D of the PC Act made out, my lords, which is the critical matter. So unless there is evidence of some kind which leads to grave suspicion, that also would not be made out. So your lordships will see on page 48, middle of paragraph 12.2.
Yes.
The middle of paragraph 12.2, about eight lines down, the prosecutor submits that there is sufficient evidence to show that these manipulations were made at the behest of A1, who had approved the final list of the selected candidates. A1 has played an important role in manipulating the original score sheets and destruction of original merit list. My lords, your lordships will see where this comes from, destruction of merit list, etc. Nowhere to be found in the evidence, and we'll show that to your lordships. Then, my lords, there are details given of how many. I've given a breakup to your lordships already. The details given of how many have been affected. Then page 49, your lordships will see. Your lordships had advisedly used the word subjective and objective. And what it seems is that this is entirely done on a subjective basis. Here again, just before paragraph 12.3, the last three lines, the charge sheet reveals unlawful interference and manipulation. My lords, they are relying on annexure 8, which we showed to your lordships, annexure 8. And the prosecution submits that there is prima facie evidence, etc. This is just stating to be so. It has to show what the prima facie evidence is. Then, my lords, at 12.5 at the bottom,
yes,
the prosecutor, in order to manifest the involvement of A1 and A2, submits that A1 had given 2 lists of candidates to A2 for the selection of candidates, which was recovered from the possession of A2. My lords, what is recovered from possession of A1, A2? It does not link up with what the slips were, nothing at all. It's just simply because there's a recovery of something, there would be many lists, etc., but they've not shown how anything in the so-called second list has in any way changed what was the first list. So, my lords, that your lordship will find nowhere. It is not put down anywhere. Then, my lords, 12.6 criminal conspiracy. They jump to criminal conspiracy. Then, my lords, 12.7. I've already conceded to your lordships that they may, for purposes of your lordships examining this, that
Yes.
there may well be endorsement which is on slips. Whether that endorsement will finally hold in a trial or not, but 12.7 talks of endorsed must, given the writing on the document has been confirmed by an expert belongs to A1 with prima facie reveals involvement of accused A1 and A2. But I've already said forensics indicate that there is signature or handwriting on the slips, but not on any of the merit lists or the selection score sheets, etc. And then, my lords, how things may have been done, correction fluid, etc., has been used. Your lordship may please come to page 52.
Yes.
Well, these are the arguments that we had made, and then I've just repeated that if your lordship will see page 52, paragraph 13.3, the last 3 or 4 lines of paragraph 13.3, the score sheets of the qualified and eligible candidates were prepared and signed by all members of the board before it was sent to A2, which only goes to show that A1 had no hand in the selection process of the candidates. My lords, I showed your lordships in those columns that I indicated that they were signed by all members, and no member has said that we were told to do something. No member has said that what we did is not the shape in which you now produce the charge sheets, the mark sheets, etc. And then, my lords, it goes on to repeat the same thing, that there have changes have been made, etc. And finally, at the bottom of 52, that A1 is only, the allegation is that her handwriting was found on the recommendation letters and not on the score sheets. I argued that before your lordships a moment ago, and I've argued that again. And my lords, this continues in this manner. It's, as I said, argued almost in a subjective manner. And it finally, my lords, if your lordship will come to the decision, which is at page 57. My lords, I can't cavil with paragraph 15.2 that no detailed reasons need be given. That I have no issue on that, on section 227, etc., etc. Then, my lords, critically 15.6. I believe this is an important point, my lords. Sheila Sebastian, I'll place that judgment before your lordships.
Yes.
Where it is very clear that the forgery can only be charged against the person who's done the forgery. Well, that's why I said there's an attempt to telescope that she's done this herself, that she kept it with herself and did it herself, rather than having told somebody to do it. Sheila Sebastian is very clear. But the learned judge, my lord, comes to this conclusion in the last 3 lines of Sheila Sebastian reference. The decision of Sheila Sebastian was arrived after the trial on appreciating evidence adduced during the course of trial. In the case in hand, the materials on record are scrutinized for the purpose of framing of charge. The court has to form an opinion from the material on record if presumption can be drawn from an offence. The correction and veracity of the materials cannot be gone into the stage at this stage. Well, there's no question of going into the veracity of the material. The question simply is, when you are arguing the prosecution that these papers were the interpolation was done by somebody on the behest and instructions of A1, is that covered by Sheila Sebastian? And my answer is, my lord, it's not covered. It is not covered in matters of culpability in Sheila Sebastian, and there is now no further facts to be verified in order to come to a conclusion that Sheila Sebastian applies. So, my lord, Sheila Sebastian is the law, that you cannot hold a person liable for forgery if that forgery has not been done by that person. They themselves said that this was done at her behest. In Sheila Sebastian, whatever was done at the behest of the person who was being charged. And Sheila Sebastian says very clearly that you can't be held guilty of forgery if it is done at your behest, because forgery must be done by the person concerned who is to be charged. And therefore, my lords, on Sheila Sebastian, my learned friend, the honorable learned judge has gone wrong. Then, my lords, there is this issue of conspiracy. I will give those judgments to you. My lords, the various centers, Shillong, Jovai, at page 60, have been considered. Those are essentially reproducing what I showed to your lordships in those columns.
Yes.
Then, my lord, if your lordship would come to page 62, paragraph 15.16. Yes, your lordship may note, in view of what I said on Sheila Sebastian, learned senior counsel for A1 has advanced the argument distancing A1 from the material on record on the ground that there is no evidence to show that the entire alleged manipulation was under the influence of A1. The evidence on record points towards the board members and A2, etc. And then just skip 6-7 lines, my lord. But it has been alleged that chits, slips, notes under handwriting of A1 were found in possession of A2, and the same cannot form the basis for framing a charge. But the fact remains that there is prima facie evidence that chit and note are in the handwriting of A1. It was alleged recovered from possession of A2. Same has nexus with the alleged manipulation of the score sheets. So, my lords, they cannot go on one hand to say she is manipulated, and on the other hand to say it was manipulated at her behest or under her instructions. Two different things as far as the issue of forgery is concerned. So they have to accept. And my lords, the learned judge may have, I believe, given too much leeway to saying that this matter can only be decided after trial, when clearly Sheila Sebastian stands in their way, and therefore, my lords, a trial would not be justified. Your lordship will now, the last 2 pages are left, my lord, 63, my lord, paragraph 15.18.
Yes.
My lord, this is what your lordships had queried me on. Middle of 15.18, about 10 lines down. Further, public representatives who were involved in recommending the names of the candidates have been exonerated. A1, being a public servant, cannot be isolated and fastened with criminal liability as stated above. These arguments are on merit of the matter, perhaps may constitute defense of the accused persons, which cannot be ground for discharge. My lords, whether the same yardstick is applied or not applied, not only for purposes of Article 14, but for purposes of what is your yardstick for culpability. So if the yardstick of culpability does not apply to public representatives, there has to be some additional factor that it will apply to a public representative in distinction from all the others who recommend it. Or would it just be recommended by some, recommended by one, and then it becomes non-est, because this is not, as the pattern I showed to your lordships, this is not what has finally influenced the decision. There is a coincidence of certain numbers, and 11 numbers are the ones that I showed to your lordship there in those lists, that there is a coincidence of some, but then so many that have been recommended have not been selected, so many who have been recommended have been selected without tampering, and therefore it cannot be said that this pattern points to a case of a grave suspicion that this is what would have happened. If somebody wanted to interfere, they would have said this and no more. Make sure that these people get in. But that is not the kind of instruction that has either been given or the kind of instruction that has been followed. So, my lords, finally, at the bottom of page 63, the learned judge comes to a conclusion that this is a matter for grave suspicion and not just a matter of suspicion, because this is not a matter of arbitrary allotment of marks, but a case of tampering, manipulating, destroying. Well, it's simply repeating these words would not add to the grounds on which culpability at the stage of framing of charge can be instituted. Then your lordship will come finally to middle of page 64.
Yes.
There are also materials on record which prima facie reveals mass manipulation, large-scale tampering in the score sheets by obliteration, application of white correctional fluid, insertion and overwriting in the original score sheets, and irregularity in the selection process. My lords, entirely subjective, spinning an argument of prejudice. If you put it in a larger scale, then it would be very difficult not to pin it on a person, the responsibility on a person. But as I've tried to argue, my lords, it was important that there has to be the dots have to be linked as to how this would have been possible, how this is probable, how this could be shown to be clearly involving somebody's culpability, and therefore making it necessary for the person to face trial and therefore answer the charges that have been made. Well, let's very quickly, it'll take a couple of minutes. So, let's if your lordship will see page 66 is where the charges are framed. The first charge, firstly, is of 120B, which is conspiracy. Although that's, your lordship knows that is always added. Then, my lords, section 420 is the second charge, and clearly 420, if your lordships will recall, clearly involves giving of property, handing over property under some misrepresentation, etc. Thirdly, my lords, 467, I've already argued, Sheila Sebastian, before for your lordships, 467 and 468 on grounds of forgery, and using as genuine a forged document is fifthly. So that will all refer basically back to Sheila Sebastian, and for 471 to apply knowing something to be a forged document, and then, my lords, giving false information, etc. 201, this is a consequential one. So, my lords, this is essentially, my lords, your lordships, what we will do is, if your lordships will allow me to just run down the names, the titles of the cases that I want to place before your lordship. They will be very well known to you. On conspiracy, my lords, on 120B, I am relying on NCT versus Shiv Charan Bansal. My lords, Balia versus Madhya Pradesh, Shaji versus Kerala, and Tarun Tejpal versus Goa, and finally CBI and Bora. And my lords, this in these conspiracy matters, I will place those judgments, mark the paragraphs. My lords, each one has one or two important paragraphs. Right. And then, my lords, in the framing of charge, I've already argued before your lordship, Sivji Singh and Nagendra Tiwari, para 18 is the sufficient ground that is required. And, my lords, very clearly, my lords, that section 482 issue doesn't arise anymore. The issue was about quashing and revision, so that doesn't arrive anymore. So I'll give your lordships 6, 7, 8 cases. My lords, I'll ask my colleague to place them before you with the paragraphs marked, because, my lords, the essence of my case really is what I've been able to place before your lordship. I'm deeply grateful to your lordship.
As and when you file your written argument, then the authorities relied upon, will be
I'm
grateful.
I'm grateful. Well, as soon as the prosecution is able to answer us, well, I'll file immediately the written submission, because they'll be updated to that date.
Fine.
I'm deeply grateful, my lords.
So, yes, Mr. Paul.
My lords, I appear in the other two matters just to supplement what has been argued by the learned senior, my lords. two aspects your lordships would have seen in the impugned order passed by the learned Sessions Court.
Yes.
Now, in essence, my lords, the arguments that have been raised both by A1 and A2, my lords, I deal only with A2, have not been answered by the learned Sessions Court, my lords, in the findings recorded in the impugned order. I will very quickly take your lordships to what are the findings, my lords. In the second matter, my lords, if your lordships kindly have.
Just a moment.
My lords.
Yes, you are referring to your petition.
My lords, if your lordships kindly have page 79 onwards. I'm sorry, my lords, page 74 onwards. Paragraph 15.
Yes.
Well, it says, your lordships have decisions, my lords.
Yes.
That while that upon hearing the rival counsels and on examination of the material on record, this court finds it will be necessary to deal with the scope and ambit of section 227 and section 228 of the CRPC. Before the arguments advanced by the rival counsels is scrutinized, it will be gainful to refer to Malad so-and-so, the relevant paragraphs 13 and 14. And Malad, he says at the last two lines of paragraph 15.3 for Lordship C, on perusal of record and after hearing the parties, if the judge is of the opinion that there are sufficient grounds for presuming that the accused has committed the offence, then my lord's charge has to be framed.
Yes.
Well, it's then certain judgments are relied upon. Now, your lordships, the findings of the court, your lordships will find from page 77 onwards, my lords, paragraph 15.7. 15.7, my lords, page 77.
Yes.
So these are the findings that the learned Sessions Court records, my lords. From the arguments advanced by the rival parties and on scrutiny, I'm sorry, my copy is not clear, of the materials on record, it emerges that the investigation was carried out for 5 centers. 2,500 applications were received for appointment of assistant teachers. 2,374 appeared for the interview. 370 candidates were selected. 147 candidates were kept in waiting list. 517 candidates were appointed in the year so-and-so. Later, 5 more candidates were appointed. Total number of candidates appointed were 522. The entire investigation was conducted for identifying the persons involved in manipulating of the selection list of the candidates and tampering with the marks of the candidates in the original score sheets. In the Shillong Center, out of 109 candidates, 106 candidates have been found tainted. Only 3 candidates were found untainted. In Juai Center, out of the 523 candidates, 112 candidates were selected. 43 candidates were waiting list. 155 candidates were appointed. 1 candidate who did not appear in the select list was appointed. Total number of candidates appointed were 156. Out of 156 candidates, investigation reveals only 1 candidate was found untainted. Then, my lords, he goes to Juai Center, Amlaram Center, Tura Center, Dadangiri subdivision. Para 15.4, my lords. 15.14. 14.
Yes.
At page 78, lordships. You kindly see.
Yes.
Then he says, my lords, the above materials are part of the investigation which prima facie show that the selection and the appointment was rigged and there was mass manipulation. Now, this is a finding recorded by the court, my lords. Your lordships will see on the basis of the figures that I was pointing out. He does the cursory, my lords, or rather summarizes the investigation and a finding is recorded that the above materials are part of the investigation which prima facie show that the selection of appointment was rigged and there was mass manipulation. Now, who has done the manipulation? That has never been answered by the learned court.
But is that required?
Finding is left open.
Is that required to be done so at this stage?
If he's dealing with me as A2, who is accused of a certain act, then the court would have to record my involvement in that, my lords, that there is a finding as against you. Prima facie, there is a finding as against you. What I'm trying to harp at, my lords, the court simply makes a bold statement saying that these kind of manipulations had happened.
That would have been the call of the IO.
I'm sorry, my lords.
I said that would have been the call of the IO as to
my lords,
who is culpable.
No, the court here is, my lords, the court here is dealing with my application under Section 227. I have filed for discharge. Now, why, if you're rejecting my application for discharge, you would have to record that no, there is some prima facie finding as against you, which is why, my lords, at this stage of 227, we're not going to dwell any further in the matter, and we cannot consider your application for discharge. What I'm saying is, there's a very general statement that the investigation has revealed that there has been manipulation in these centers. Very well. The question that then arises is, my lords, how does it connect me? Because unless I am connected to it, my lords, charges cannot be framed against me. Thereafter, your lordships will kindly see para 15.5, my lords.
15.5.
5, the next paragraph.
That should be 15.
I'm sorry, my lords, 15.15. This court has to be very careful while dealing with the argument advanced by the defense counsels on the merits of the matter. Inasmuch as any scrutiny on the merit of the matter at this stage would not be proper. The materials on record can be examined only for the purposes of drawing presumption if grounds are made out for framing charges. Now, the question here arises, my lords, and what has been urged by the learned senior counsel, my lords, before me. The facts, the dots have to be connected, implicating me. Now, as long as, my lords, I do not get implicated, the court, on the, my lords, general presumption that yes, there has been some kind of manipulation in the selection process, that entire thing cannot be saddled upon my shoulders. There would have to be some finding recorded by the court that yes, these are the dots which connect you, and therefore, my lords, there is a case of grave suspicion made out against you. And as such, my lords, charges would have to be framed and your application under 220 would fail. I'm not taking your lordship's time, my lords, to take your lordships to the facts which were urged by us, that is A2, before the learned court. Because insofar as only, my lords, to give a brief summary, insofar as Shillong Center is concerned, my lords, there is this Mr. Sun. Now, he says, my lords, that the original list has been submitted by him to the authorities, and, my lords, the task of the selection committee has come to an end. Now, the investigation says that the original list was destroyed. And, my lords, a forged list in place of the original list was actually put up by A2. Now, for the purposes of finding something which is forged, my lords, there has to be an original. The original is lost. Now, the entire investigation, my lords, is on the basis of a photocopy of a so-called original list, which is produced by Mr. Sun. Now, the question that, my lords, which bothers us, and I ask this question to myself is, my lords, A, what was a photocopy of the list doing with Mr. Sun?
Has that gone through forensics?
My lords, it has. It says it is an admitted position, it is a photocopy. It's a copy of the list. He nowhere says that it is the original list. They say, my lords, that the original list is destroyed. If the original list is destroyed, well, it's very well, original list is destroyed. The first question that comes is, how do you compare that this is not original? The comparison is on the basis of a so-called list produced by Mr. Sun. Now, the first question I ask myself, Malaj, why would Mr. Sun be holding on to a copy of a list which he is otherwise not supposed to be holding on to? Because he has to submit the entire list. Number two, Malaj, if what is the veracity of the list or the photocopy of the list which is being produced by Mr. Sun? Now, this is not on the merits of the matter. This is not a question of trial. It is a question, Malaj, when your lordships are framing charge, your lordships would have to see whether there are adequate materials for framing charge. Now, the foundation of the entire Shillong Center goes because of the simple reason, my lords, that there is no original list. That is the case of the prosecution. They say the original list is some list which is produced by Mr. Sun, who is the member secretary. And there is no explanation given by Mr. Sun as to how he has a copy of a list in his pocket and on what basis does he claim that this is the original list. Unfortunately, my lords, in this order, the order impute, even though this was argued at length, there is only passing references of what I have argued before the learned court below. It has not been dealt with by the learned sessions judge. Your lordship will kindly see what has been argued. Your lordship will find it at page 72.
Yes.
Malaj, so for the accused Jefferson so-and-so, Jeffrey so-and-so, after referring to the facts of this case, has drawn the attention of this court to page 14 of the charge sheet and submits the allegations are against the member secretary. This member secretary is Mr. Sun, Malaj.
Yes.
For destroying and thereafter forging, manipulating and tampering the score sheet. A2 is nowhere involved in the preparation of the final list of the selected candidates. Learned so-and-so has referred to paragraph 17.9 of the charge sheet and submits that A2 did not allot the marks and the investigation itself was not clear. The basis for allotment of marks were experienced to the candidate because I was not involved in the selection process. I was not part of the committee. Thereafter, learned counsel for so-and-so has drawn the attention of this court to para so-and-so, so-and-so, and so-and-so and submits that the nominated chairman of the board did not attend a single meeting of the so-and-so for some duty. In the interview was the interview was conducted in the absence of the chairman. The deputy commissioner Shillong directed member secretary to go ahead with the interview. And the score sheet of the Shillong Center was signed by Srimati C. Kharkongkor as chairman without attending the meeting. And Srimati C. Kharkongkor has signed the score sheets on the request of the deputy commissioner without attending the interview, and she was not authorized to sign the same. Similarly, Jacob Martin had signed the score sheets without attending the interview of on the direction of the deputy commissioner. The interview was conducted illegally without the chairman and signed by the persons who did not authorize. A2 cannot be held responsible if there is no evidence to show that A2 had any hand in the interview. So, what I'm humbly submitting before your lordships is what has been argued by us on the merit, not on the merits, my lords, on the coming to the prima facie satisfaction by the court for framing charges as against me has never been dealt with by the court, nor is it recorded by the court in the impugned order. Because your lordships will kindly appreciate that if it cannot be established that the list that the member secretary Mr. Sun has produced is the authentic list, then there cannot be any allegation as against anybody for forgery or for criminal conspiracy or any other charge for that matter. So that issue, my lords, in my humble submission, would have to be dealt with by the learned sessions court at the first instance, even before charges have been framed against me, and while rejecting my application under 227. If we go further down below, my lords,
yes,
I've taken your lordships to paragraph 15.15. Now 15.17, your lordships will again see that there is again another finding, my lords, without any reasons attached behind it or without my lords, pointing out the culpability of any of the three accused persons before the learned court below. Para 15.17, your lordships may kindly see. There is prima facie evidence that score sheets of the candidates have been tampered with correction fluid.
Yes.
Very well, my lords, they have been tampered. Tampered by whom? I ask this question to myself. The court has to record a prima facie finding that yes, it has been tampered by you, or it has been tampered by somebody else, or it has been tampered at the level of the committee. There is no finding recorded by the court. And in the absence of any finding, my lords, charges as against me cannot be framed. So, in other words, my lords, what I'm submitting before your lordships is, these are vague statements. And simply repeating vague statements, my lords, will not attach any culpability insofar as the petitioner before your lordships is concerned. Down below, my lords, my learned senior has already taken your lordships to the finding at paragraph 15.20.
Yes.
In the middle of the paragraph, my lords, there are also materials on record which prima facie reveals mass manipulation, large-scale tampering, score sheets by obliteration, application of white correctional fluid, insertion and overwriting in the original score sheets, and irregularity.
You are reading which portion?
My lords, paragraph 15.20. This was, my lords, highlighted by the learned senior counsel, my lords, in the other matter. My learned senior had already pointed out this out before your lordships.
Fine.
So,
yes, please.
This is again a very vague statement, my lords. It does not attach any culpability to anybody. And unless, my lords, what I'm harping at is before your lordships is, unless there is pinpointed allegations which prima facie, my lords, establish that there was some involvement, my application under 227 could not have been rejected. More so, my lords, charges as against me could not have been framed. Your lordships will kindly appreciate the charges against me cannot be vague. They have to be specific. If I have to defend myself, my lords, there would have to be specific charges. My lords, as such, at para 15.22, my lords, it again says that prayer for discharge of A1, A2 stands rejected. So my application is actually rejected by a non-speaking order. What has been argued before me by me before the learned court, my lords, would have to be dealt with by the court. Maybe in my favor, maybe against me, on the basis of materials which were available before the court, with some reasoning as to why what I'm submitting before the court for that there not being any prima facie cases against me, that would have to be, my lords, overturned. That no, on the basis of this, the three dots would have to be connected and say that there is a prima facie suspicion or grave suspicion that you are connected with this matter, and therefore your case for discharge at this stage cannot be considered and it is a matter of trial. The learned court does not do that. What the learned court simply does is, my lords, on the basis of certain surmises and conjectures, it says that your application under 227 has to be rejected. My humble submission before your lordships would be, my lords, this order is otherwise, my lords, bad in law because of the simple reason it doesn't deal with the contentions raised by the parties. Insofar as I am concerned, my lords, my prima facie grievance is, my primary and my only grievance is that whatever had been argued by us before the learned sessions court has never been dealt with. And your lordships would kindly see the last paragraph at 15.23. Now, this again has a bearing. It says, my lords, even though it is very innocuous, but in the larger scheme of things, it has a bearing. This court makes it very clear that any observation made by this court shall have no bearing on the merits of the matter. Now, the question arises, my lords, and I ask this question to myself, that your lordships have seen the law. Unless there is certain amount of culpability which is attached to me, maybe as a prima facie view, can I be put to trial? And the learned court, my lords, below puts a caveat to the findings recorded. I've taken your lordships to what are the findings. The findings are general, they are vague. And the learned court says that they will not have a bearing insofar as the merits of the matter are concerned. So if this be the position, my lords, where is the culpability of A2 for him to face trial? So the least your lordships would do is when I'm arguing a certain matter before your lordships, my lord, I'm harping on certain factual aspects which go to the root of the entire matter. Your lordships would have dealt with it. That because of this reason, this argument cannot be accepted. And these are the documents which prima facie show your involvement in the entire matter. And therefore, my lords, it's a fit case to go for trial. That burden, my lords, has, in my humble submission, has not been discharged by the court below, which renders this order, my lords, fallible in law. And this order has to go. So your lordships would, therefore, my humble prayer before your lordships would be, my lords, that this order needs to be set aside. The matter needs to be remanded back before the court below, with directions that the entire matter, my lords, whatever is being urged by A2, insofar as I just briefly pointed out, my lords, what was there, that has to be dealt with. Some culpability, prima facie or otherwise, has to be fixed. If at all, my lords, charges have to be framed as against him, which would then enable me to defend the case. Because my lords, the stage of 226, your lordships are well aware. It is not an empty formality. The reason why 226 is there, my lords, that upon investigation, the court applies its judicial mind to the charge and sees whether any culpability can be attached to the persons who are said to be, my lords, associated with that particular case or that particular charge sheet. Now, if the charge as against, my lords, is a vague charge and does not attach any culpability to the person accused, there would be no occasion for the matter to go into trial.
And you see, materials will have to be looked into. Findings have to be.
If your lordships, so please, my lords, if your lordships so please, I can take your lordships to Shillong Sub-Center, my lords. What I was urging before your lordships, I can very quickly take your lordships to the Shillong Sub-Center and what has happened in the Shillong Sub-Center, Shillong Center. Because prima facie, my lords, it establishes that there is no list. And some list which somebody takes out from his back pocket and says that, oh no, I have a copy of the original list. That is the foundation of an investigation.
That you have gone through that.
No, I have just made a very general statement, my lords. If your lordships so please, I could take your lordships to the charge sheet as well as the statements of the this Mr. Sun and the other 3 members of the selection committee, my lords. Because that would establish that whether there is a list. If there is a list, my lords, then there can be question of that list being tampered with. Only if there is a list, my lords, it can be tampered with.
So this court will look into whether the trial court has examined that matter, whether it has taken everything into consideration, and whether your contention,
your lordships are absolutely correct, and I'm grateful, my lords, but your lordships will kindly appreciate my difficulty. My difficulty is the court does not even record what has been submitted before it. Rather simply says, I've taken your lordships, paragraph so-and-so, paragraph so-and-so, paragraph so-and-so.
But it's not necessary. You see, Mr. Paul, you know very well. No, it's not right. It's not. Even proper for the court to go into each and every detail of your argument, has to note it down word by word.
No, I'm not saying that.
What the court would do is, take your submission at face value and come to its own. The language would be the language of the court as understood by it.
My lords, I bow down. But the issue is, your lordships have seen what has been recorded by the learned court below insofar as my arguments are concerned. Your lordships would have seen that the name of the person concerned itself though finds mention. The issue that I've urged before your lordships, that if there is a list and whether it is the main list or whether it's a false list, would have dealt with that. This has been argued by me and this is the answer to that argument. It is not there. So what I would pray before your lordships is, my lords, that if your lordships grant me this liberty, I can very quickly take your lordships to the charge sheet, that what is the charge by the CBI, and my lords, what are the facts, the attending facts towards that, from that particular subcenter. And my argument would simply be that, as I've, and I, my lords, at the risk of repeating myself, that once there is no list, there cannot be a case of there being any interpolation on that list. Somebody would have to come to a finding, my lords, that this is a list. And this is the list on the basis of which the allegation is that it has been tampered with. And this is only with regard to Shillong Center. The other centers, there were another series of arguments. None of it has been dealt with by the learned court below. That's my grievance. So your lordships have said on repeated occasions, my lords, that when your lordships are dealing, when any court is dealing with the arguments, my lords, made by any accused, in support of his case, your lordships will deal with it. I cannot be left abandoned that simply saying that these touch upon the merits of the case, so therefore at the stage of 227, we're not going to touch it.
Granted.
But your lordships, whether your lordships would be pleased to allow me to take your lordships to the charge sheet, my lords.
Yes, please do.
Yes. Well, it's the charge sheet.
Where have you annexed it?
My lords, it is. This is Annexure 3, my lords, starts from page 35. Lordship, just bear with me for a second, my lords, because I'm doing it for an e-copy.
Would be page 36.
Yes, my lords, it starts from there.
Yes.
Of course, my lords, the statements of these three persons who are the members of the committee, that is not on record before your lordships, my lords. That is part of the charge sheet, but that is not on record. Because the charge sheet, it is a huge voluminous charge sheet which has been filed by them.
Is it? It's not. I mean, the complete charge sheet is not before the court.
I'm sorry, my lords.
The complete charge sheet is not before the court.
No. My lords, the complete charge sheet will run into a few thousand pages.
Is it necessary or required for this court to go through all those?
No, my lords. I am only with regard to Shillong Sub-Center, only those three, the statements of those three people, because he says, Mr. Soon very categorically says that he has submitted the list, he had nothing with it. Then subsequently he takes out some piece of paper and says that this is the original list, I have a copy of it.
Exactly, but that
I am only on that.
But that statement is not here. It would be in some other volume, part of the, the charge, the original
it is
charge.
Part of. If your lordships permit me, Malas, I could quickly just have those three statements made into an extra copy and serve it to
Dr. Muziga, you have the charge sheet with you.
Mr. Panthi would be having those documents, Malas.
But that is only to prove a point.
That is, my lords, because the foundation of the charge would go. If there is no list, my lords, there cannot be any. There cannot be any interpolation on any list. What I'm trying to show is, my lords, that for an investigation of this magnitude to commence, there has to be some sound material. It cannot be on the basis of thin air. That somebody comes out, my lords, takes out a piece of paper saying that this is the original list. I had given the main list to Mr. X. and I have a copy of that list. Now he does not explain how he has a copy of that list. May I make a small prayer, Your Lordships? Let my friend Dr. Mosika respond to whatever has been argued by the learned senior counsel if he so wants to proceed. Only on this aspect, my lords, may kindly pass over the matter for tomorrow. We will have 5 pages of those statements prepared for Your Lordships separately and placed before Your Lordships. Your Lordships will allow us to very quickly just point it out and Your Lordships will deal with it. The greater substance of my submission is, my lords, that the arguments raised by us have never been answered by the court below. And therefore, my lords, this order is otherwise bad in law. Because they would have to be dealt with. And they have never been dealt with. So this order otherwise has to go.
No, in that case, Mr. Paul, I think
but
we'll continue with your argument. But having a break here and allowing the petitioner to respond.
May I pray Your Lordships? May I pray Your Lordships have it then tomorrow, millions?
So we'll have it tomorrow. So, Mr. Khurshid, as far as you're concerned, I think you're done.
Well, just in case, the prosecution brings up something that
yes,
I need to respond to, then
that you can do.
I'll just leave it at that. I'm grateful, Balance.
Right. We continue tomorrow, Malins.
Heartland Council for the petitioner matter to continue on the next day. Matter to continue tomorrow as prayed for.
Instead of tomorrow, can I pray for Monday? I have some health issues. Tomorrow is Friday.
Monday. Weekly. We'll have it on 11th. Because 11th, I think the boat is a bit, short.
Next Wednesday.
We'll continue on 11th, Mr. Khurshid.
Please, Millets. Please, Millets.
Well, it's 11th.
As prayed for, let's this matter on 11th.
Well, obliged.
Thank you.
Second call from supplementary course list, item number 3.
Slide that up for me. Mr. Thaba, I saw him here.
Hey, please, Your Lordship. Lordship, Mr. D. Thaba is on his way.
Oh, yeah. Mr. Thaba.
Yes, Your Lordship. Your Lordship, in writ petition number 118 of 2022.
No, we are on supplementary.
This is 184.
183 and 184.
Oh yes, we are on the issue of whether you can come up with new pleadings or fresh
additional
pleadings
documents, Your Lordship.
in the form of additional comments, whatever. At this point of time, Ms. Versace is to respond to that, whether you would agree or not.
Lordship, it is a. I was not aware on last occasion that he will be coming up with this. So I thought he will be filing written argument. Oral argument is already over, Lordship. It is supposed to be posted for judgment. Written argument is just for court perusal, means it is easy for court to deal with the matter. For that we place written argument, but written argument is always based on the oral argument. Oral argument he did. That time he did not raise such things.
No, that is not the point. From what I could understand, the petitioner, okay, oral argument done, written argument is to be filed, which is due. But at this point of time, it suddenly struck the mind of the petitioner that, oh, I've forgotten something, which is very vital and relevant to the case of the petitioner. So the leave of the court is sought for to produce certain documents in a form of an affidavit or otherwise. Primarily, this court would not, have allowed to do so. Would not have allowed the exercise to be done, considering the fact that, like you rightly said, the matter is the fact end of the proceedings. But on the other hand, would it be proper for the court not to allow complete justice to be done, wherein all the parties are given the fullest use of their argument or their pleadings or otherwise? That is basically the issue that we are here. I have requested Mr. Thaba that your argument is noted, but if you can come up with some decision, some argument to help you, that would help this court. Otherwise, at this point of time, considering the fact that this matter is very, very long pending, had it been a year or two, perhaps.
Lordship, I was supposed to come on that.
Do you have any? Yesterday, I had requested you to bring some
Citations, Your Lordship. Citations, Your Lordship, I could not find. Yeah, because yesterday I was out of station. But that was day before yesterday.
Was it? So, even in that case, you've got 1 day to do some research.
Your Lordship, my main
The mind of the
contention.
court is, midway now, whether to allow you or not. Because you also have to think of the rights of the respondents, and how material it would be to the facts of this case. If it is so important, you could have done that, a long time ago.
Yes, Your Lordship.
It is because it is not so important you have done it now.
It is through oversight, Your Lordship.
Lordship, now this is the second round of hearing it happened. Lordship, first round of hearing already conducted. Then due to the lapse of time, Lordship was pleased to call for the second round of hearing because to refresh the memory of the Lordship. During first round also he did not realize that it is a matter of 2017. Now already we have passed around 6 years. After 6 years, he is realizing that he has not produced the documents. Now, whether he is allowed to, because the Act also has to he has to go by the Act, whether the Act provides him to do that or not. Act also is not allowing him.
Mr. Thawa, what you can do, you file your written argument.
Yes, Your Honor.
Confine yourself to the pleadings. But if that is, if you are relying on that on any aspect of the matter which you feel is important, then you do that by relevant authorities. Make a reference to such authorities, and if the court finds that it can be taken on board, it will be. But going to the process of filing new pleadings at this point of time, I don't think.
Not new pleadings, Your Lordship. Just additional documents.
Of course, additional documents. That is also a new pleading, because they would bring in new facet to the proceedings.
And there's some Your Lordship, I leave it to the discretion of Your Lordship.
Heard Mr. D. Thaba, the counsel for the petitioner. The court, upon hearing the counsel for the parties, at this point of time, has carefully considered the submission made and the submission and the prayer made, and taking into account the pendency of this matter and also the fact that it is at the fact end of the proceedings, in as much as the stage is only for filing of written argument, the prayer of the petitioner would verge on to the extent of the conduct of the petitioner being one of irresponsibility or one of irresponsibility resulting in lapses and latches in the conduct of the case. Be that as it may, the court would consider the arguments of the party on the basis of the pleadings herein. Accordingly, the petitioner is requested to file a written argument at the earliest. You have not filed?
No, Your Lordship. Your Lordship, next week I won't be in station. I have to go to Guwahati for some matters.
What you can do, you can prepare the written argument, get your colleague to file it.
Yes, Your Lordship, but the thing is, I won't be in station.
Anyway, so 2 weeks then. This is
2 weeks, Lordship, then it will go obviously on 3rd week because the after 2 weeks.
Yes, so it will obviously go.
On the 3rd.
You will have plenty of time to do it.
During puja. But that may be a last chance, Lordship, because we are also under pressure. It's 2017 matters. Exactly. I am under pressure to
Your Lordship, I will come to that on the
this
regarding the other matter.
This is matter after puja vacation.
Second call from daily cost list, item number 1.
This is fixed for?
This is fixed for filing of rejoinder by me. I have served a copy. Actually, I was supposed to file yesterday, but I couldn't serve copy to Miss.
Have you done it?
I have served the copies.
You have received
Yeah, we have received the copy.
Then a counsel for the petitioner has.
Your Lordship, in this, I'd just like to say that the petitioner company is a 50-50% equity shareholder with the government of Meghalaya. But I wonder why the government advocate, even day before yesterday, had objected so strongly against the petitioner company, in spite of the petitioner company being a 50-50% partnership of the government of Meghalaya.
I think here, is this the case where that
notification has been challenged?
The exemption notification and the withdrawal of the same. As far as the state is concerned, who has issued the notification? The state?
Yes, Your Lordship.
Yes, the state.
Oh, you see, those are matter of records. Yes, the state is just to show that this is the notification, it has been issued, it has been withdrawn, and that's all.
No, Your Lordship, what I mean to say is...
where is the question for them to oppose you?
No, or even on a day before yesterday, my learned friend had strongly objected to my submissions, in spite of...
What was your submission?
He had regarding that the previous matter which...
Why are that matter is over and done with?
He had strongly objected, in spite of the fact that the state and the petitioner company are 50-50% equity partnership.
You make a note of it in your written argument in the other case, and we'll see the role of the government then.
Yes, I will.
So as far as this case is concerned, matter will be posted for hearing.
Matter will be posted.
Yes.
Well, as submitted that the rejoinder affidavit has been filed, to which the General Counsel for the respondents has also agreed that a copy of the same has been received. Accordingly, as paid for as submitted by the parties, this matter is now posted for hearing. This is the same after the puja vacation.
Highly obliged.